Shout out to the Fighter and the Kids subreddit because we have the documents of Bryan Callen's lawsuit. So let's go through this. So Andrew Baum, that's Bryan Callen's lawyer, Jesse Levin, Glazer, Wheel, Fink Howard, Avetchin, and Shapiro. I guess that's the law office he's using. Superior Court of the State of California for the County of Los Angeles. Bryan Callen, an individual plaintiff, versus Gabriel Tigerman, an individual, and does 1 through 10. I guess he's suing other people too. Complaint for international interference with contractual relations and demand for a jury trial. So Bryan Callen wants a jury trial. Plaintiff Bryan Callen alleges as follows. Nature of the action. This lawsuit arises from defendant Gabriel Tigerman's ongoing campaign to destroy the livelihood of actor and stand-up comic Bryan Callen through threats, harassment, and intimidation of third parties that dare contract with them, driven by the false allegation that Mr. Callen assaulted his wife over 20 years ago. Mr. Tigerman has sent and continues to send Mr. Callen's representatives and others direct demands that they cease doing business with him or else be falsely branded as supporters of assault. Damn. As a direct result of Mr. Tigerman's vengeful interference, Mr. Callen's agents dropped him and comedy clubs have canceled contracts to perform. This is illegal, wrong, and without regard for due process. By this complaint, Mr. Callen simply seeks to preserve his ability to work and earn a living. Parties. Plaintiff Bryan Callen is an entertainer who makes his living as a film and television actor, writer, podcaster, and stand-up comic. He resides in the county of Los Angeles. Upon information and belief, plaintiff alleges that defendant Gabriel Tigerman is an individual residing in the county of Los Angeles. Upon information and belief, plaintiff alleges that each of the fictitiously named Doe defendants is responsible in some manner for the occurrences herein alleged, and that Callen's damages, as herein alleged, were actually and proximately caused by their conduct. Upon information and belief, plaintiff alleges that at all material times each defendant was the agent, servant, authorized representative, predecessor, successor, co-conspirator, employer, and or employee of each other, and in doing the things and acts alleged in this complaint was acting within the course and scope of said relationships, and further that each defendant has authorized, approved, ratified, and or endorsed the acts of each remaining defendant. Further, each of the defendants was a partner or was engaged in a joint venture with one or more of the remaining defendants, and was acting within the scope and purpose of said partnership or joint venture. Each defendant has ratified each and every act of each other cross-defendant pertinent in said partnership or joint venture. We don't care about the venue. That's going to be in California, obviously. Facts common to all causes of action. Plaintiff Bryan Callen is a well-known actor and comedian who got his first break as part of the original cast of hit late-night show Mad TV in 1995, like Artie Lang. In the years since, he has regularly appeared in film and television and toured as a stand-up comic. To perform as a stand-up comic, plaintiff Bryan Callen contracts with various comedy club venues and live theater chains across the country. The identity of these venues is public knowledge because Mr. Callen publishes his tour schedule on his website, bryancallen.com. To procure work as a stand-up comic, Mr. Callen contracted with Creative Artist Agency, CAA. To procure acting roles, Mr. Callen contracted with Innovative Artist Talent and Literary Agency, Innovative Artist. At all relevant times, Mr. Callen's representation was public knowledge. Anyone, including defendant, could find his agents. Contact information at CA and Innovative Artist on numerous websites via a simple Google search. On July 31st, 2020, the Los Angeles Times published an article wherein Catherine Fiore Tigerman accused Mr. Callen 21 years ago. Defendant Gabriel Tigerman is married to Catherine Fiore Tigerman. Mr. Callen never assaulted Mrs. Tigerman. All the allegations of Mr. Callen's misconduct published in the LA Times are false, and Mr. Callen has publicly denied them. Moreover, Mr. Callen has never been charged with nor convicted of assault. 20 days after the publication of the LA Times article, defendant Gabriel Tigerman sent Mr. Callen's representatives a demand that they drop Mr. Callen as a client. In particular, on August 20th, 2020, Mr. Tigerman sent an email to CAA stating, "My name is Gabriel Tigerman. I am sure you are aware of the heavily vetted assault allegations against your client, Bryan Callen, detailed on the front page of the LA Times a few weeks ago. 4 women came forward for this article. My wife, Kathleen Fiore Tigerman, is one of them. Bryan Callen assaulted her 20 years ago. I know CA dropped Bryan's close friend and partner, Chris D'Elia, when the LA Times reported of his accusations. I can only assume his representatives knew that by continuing to represent D'Elia, they would be standing with abusers. It would be sending the message to victims that this behavior is okay. I am writing to find out what the status is with Callen at CAA. Do you and CAA still represent this predator? I hope the answer is no. I swear to God, if Chris D'Elia gets called as a witness in this trial, I'll laugh." All right, it continues. Emphasis added. Upon information and belief, plaintiff alleges that Gabriel Tigerman sent this email or one like it to Innovative Artist on or around the same day. As a result, one day after receiving Mr. Tigerman's email, both CAA and Innovative Artists quit representing Mr. Callen and refused to continue to procure him acting and comedy work pursuant to contract. The loss of Mr. Callen's representation contracts forecloses the possibility of future acting and performance jobs that only a licensed talent agency can procure on his behalf. The resulting loss of future earnings to Mr. Callen is immense. Damn. Gabriel Tigerman continues to communicate similar harassing and threatening message to other parties with whom Mr. Callen has contracted or has business relationship. For instance, in September 2020, Mr. Tigerman called and wrote various comedy venues with whom Mr. Callen was contracted to perform in October and November, including Bricktown Comedy Club in Oklahoma City, Oklahoma and Skyline Comedy Club in Appleton, Wisconsin. Mr. Tigerman told these venues that by not canceling their contracts with Mr. Callen, they were sending the message that they support abusers and do not believe victims of assault. Following Mr. Tigerman's communications, the Bricktown Comedy Club and Skyline Comedy Club canceled Mr. Callen's contracts to perform at their venues. In sum, Mr. Tigerman has engaged in a relentless campaign of economic interference against Mr. Callen as revenge for something Mr. Callen did not do. Mr. Tigerman's apparent objective is to have Mr. Callen blacklisted, destitute, and never work again. The direct impact has been nothing short of devastating to Mr. Callen personally and financially. Mr. Callen's growing damages are well in excess of a jurisdictional requirement of this court. By the complaint, Mr. Callen seeks to halt Mr. Tigerman's misconduct and be made whole for the undue harm it has inflicted on his entertainment career. Cause of action. Plaintiff Bryan Callen refers to and incorporates by reference all the allegations in paragraphs 1 through 29 and is fully restated herein. There were contracts between Mr. Callen and the following entities: CAA, Innovative Artist, Bricktown Comedy Club, Skyline. Defendants knew of these contracts, defendant's conduct prevented performance or made performance more difficult for each of these contracts. By, among other things, communicating demands that the third party stop contracting with Mr. Callen, sending harassing and intimidating messages, and threatening to publicly brand the third parties as supporting assault abusers. Defendants intended to disrupt the performance of these contracts or knew that disruption of performance was certain or substantially certain to occur. Plaintiff Bryan Callen was harmed. Defendant's conduct was a substantial factor in causing Mr. Callen's harm. Mr. Callen has suffered and will suffer in the future damages in an amount to be proven at trial. Defendant's conduct, as set forth above, was in willful, malicious, fraudulent, oppressive, outrageous, and committed with the conscious and reckless disregard to the consequences, thus justifying punitive and exemplary damages against defendants in an amount sufficient to punish defendants for the severity of their conduct. Prayer? What are they praying? For actual damages, according to proof at trial, for prejudgment interest on all damages at the legal rate, for punitive damages, according to proof at trial, an amount sufficient to punish and make an example of defendants for their wrongful conduct, for attorney's fees as permitted by law, for cost of sue, and for other such relief as court deems just and proper. Dated September 23rd, 2020. Now, the guy who dropped this, by the way, and then it just demand for jury trial, was also the same guy who said Callen is suing Cast Media. He hasn't gotten that paperwork, but that's the lawsuit. Let me know your thoughts in the comments.